And welcome to Secure Your Creations podcast with Mario Milano. I'm your host, Craig Andrews. And Mario, tell me about yourself today. How are you feeling?
Pretty good, Craig. With this warm weather returning, everybody's got a smile on their face, I think.
That means basketball season's ending and baseball season starting, right?
Yeah. And both good things.
Absolutely. So today we're going to talk about trademarks. I know that's one of your service lines that you offer in terms of trademarks. And so just to make sure that everyone's clear in terms of what trademarks are, kind of give me the difference between trademarks, copyrights, patents, in addition to why is that important for small businesses?
Sure. So a trademark is going to be the identifier for a source of goods. We can think of some of the common trademarks like Pepsi or Coca-Cola for soda. If you buy one brand, you have an expectation for what the flavor is going to be. And the trademark helps you identify what the product is. A trademark is different from a patent because patents really protect the underlying idea of something. But the patent isn't really concerned with who the source of a good is. The patent is really just protecting the idea. Whereas the trademark, you would know who you're buying it from. And a copyright is more for a creative work. And again, is not really concerned with who is the manufacturer of something, just that it's protecting the work itself. So if you're a small business and you have your product lines and you want to make sure that everybody knows the high quality products that you're putting out, then a trademark is the way to go.
And so thinking about the shows and movies of the past, I'm a big movie buff. So seeing Coming to America, and they had McDowell's and McDonald's. And even in the movie, it's funny is because they reference in terms of there's people over here always taking pictures and making sure I'm not breaking the copyright and da 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 and so forth. That's what I think about when I think about the trademarks as you're referencing it. So in terms of those examples of big, now McDonald's is a big brand. What about the small business guy? How does trademarks affect them?
Yeah, the trademark is still going to affect and impact small businesses. One of the ways that I see it for small businesses that don't acknowledge trademark laws and just kind of ignore it, sometimes they get a cease and desist letter from either a bigger company or just another small business that has a trademark for something that my client is using, and that's not what we want to see, because now all the effort that the client has put into not only establishing their brand and getting customers to recognize it, but also the expenses that they've paid. They usually have products that are already out there, and all that stuff has to be taken care of if you are accused of trademark infringement. And so, clients should, from a defensive standpoint, they should be aware of trademarks and other people's trademarks, and they also want to make sure that they have their own trademarks so that nobody else can come in and try to compete against them using their own intellectual property.
So tell me about that process. What would a client have to do if you were engaged with them in terms of setting up that trademark to protect themselves?
Yeah, it's trademarks are relatively faster than patents. There's not as much pen to paper work for an attorney. Still work that has to be done, and the scope usually looks like, number one, I always recommend that you get a search done. That's gonna, number one, make sure you're not going to be infringing the rights of others, which is very important. And number two, we can usually get a really good idea of whether your trademark is going to be something that's actually protectable or not. There's different requirements for a trademark application. It has to be sufficient for a source identifier. And once we go ahead and make sure, okay, we think it's going to be protectable, you're not going to be infringing the rights of others, then we'll submit the trademark application. It typically takes about 6 to 8 months once we file it until we hear back from the trademark office. And ideally, the application will just be allowed at that point. Sometimes we do have to have a little bit of a back and forth with the trademark office, and then the application gets allowed.
So can you give me a real life example of something that went maybe not as great for a small business that didn't have a trademark situation?
Yeah. The situation that I see with that is the most often way that it comes up is just they don't do a search for anybody else's trademarks. They start selling their products. They have an established brand now with some recognition in the marketplace. And as consumers start to recognize that brand, trademark owners also start to recognize that brand. And so if you have a name or an image or a logo that you're using that's confusingly similar to somebody else's trademark, then the trademark owner will then send you a cease and desist asking you to stop using that trademark.
That makes sense. That makes sense. So a lot of times in small business owners that we both work with, they tend to kind of escape over the details. So tell me about the cost benefit versus not doing it the proper way. What is the benefit in terms of how do you justify that to a small business owner?
Yeah. So, the number one thing, like I said, the number one thing that I always recommend is the search. We can usually do a search for about $500 for a single trademark. And so, the fee for that, sure, $500 is some money. But the cost associated with not doing the search and just starting to adopt a brand new trademark for yourself or a brand new logo without doing the search, if you then have to rebrand and adopt a new mark later, that's certainly going to cost you a lot more than the original $500 just to make sure. Some clients are hesitant to do it because they've already established their new brand, or they've already, worked with some creative folks to come up with the new logo and they're excited to start using it. So they don't want to get bogged down in the details of having to do a trademark search and then start over.
Well, I know with yourself, you're more of a proactive thinker, right? So ultimately you want to make sure that you're being careful not to have an accrued cost of legal fees and defense and everything of that fashion. So the word to the wise here is do it right the first time, ultimately.
Yeah, absolutely. The legal fees certainly start to add up. The search is relatively cheap. The fees to respond to cease and desist letters and making sure we're complying with everything that the other side is requesting, that certainly starts to add up. So, the initial fee is usually well worth it in the long run.
That's right. And $500 investment into your business is generally pretty low, I would assume, considering we're all growing businesses to get bigger. Very few people said, I want to grow a business and stay small and deal with minimal amount of people. So as you begin to grow, you want to make sure that your legal stuff in reference to your trademark is set in place. And you want to do that early and often. Tell me a little bit about Milano IP's process when it comes to maybe how often should you check your trademark in terms of infringement?
Yeah. So we do offer an ongoing monitoring service. And so we have software that just is constantly scouring the internet and other sources to make sure that, is anybody using a mark that's similar to yours? If they are, what type of goods are they selling it under? If you have a company that sells construction equipment, well, then somebody else who starts manufacturing a food product, that might not be as much of an issue as far as your trademark is concerned. But if it's somebody who is selling construction tools under the similar mark, then that's certainly something that we want to know about. And so we have software in place that just is constantly monitoring that. And, usually it's kind of a set it and forget it thing. We just run the search. And if there's no issues, then we don't bother. We don't need to let you know. But if something does come up, then we can reach out and let you know right away.
So you bring up an interesting point there, and we're talking about probably more myths. And as a novice, I wouldn't know the difference, but that's why we're here talking to you. So you mentioned there in reference to being in different industries. Tell me some examples of when it doesn't matter if your trademark's in place, if you're in a different industry than your trademark is in, or if it does or doesn't matter at all. Like, should you still stick with the cease and desist letters and things of that fashion?
Yeah. So the issue comes up. Sometimes it doesn't matter, but a lot of the time it depends on the other person's trademark. If we're looking at it from an infringement standpoint. So if somebody else has a very famous mark, then whether you're in their industry or not, there's a high likelihood that they're still going to tell you to stop using their mark. For example, if like the Walt Disney or Disney trademark, that's a very famous mark. Everybody knows about it. And whether it's in a particular area that Disney has filed that trademark application in and has a trademark for those goods, or if it's an unrelated one, the likelihood if you start using Disney's trademark for an unrelated product, they're probably still going to be able to say that you're causing confusion in the marketplace with their trademark because they're that famous. Now, if it's a relatively unknown trademark for banking services and you start using it for your landscaping business, it's the likelihood that you're causing confusion in the marketplace is significantly lower than it is with the Disney example.
That makes sense. And so a couple questions I have from that answer is, when you're talking about trademark, and I know you somewhat answered before, but when you're talking trademark, are you talking color? Are you talking scent? Are you talking size? Like what type of things really fits under that trademark moniker?
Yeah. And so those are all things that we can apply for. Typically, when clients first come to me, they'll have either their business name or their business logo, and they'll say, okay, I want to get a trademark on this. Typically, just getting the name itself in plain text is usually the broadest trademark. But once they file that one, then they want to adopt a logo so that they can then start incorporating their business colors into their trademark. Then we can go that route. I just saw, like the Reese's peanut butter, that color of orange. They have a trademark on that. Those are more complicated trademarks to get because we have to show that there is sufficient brand recognition in the marketplace in order for somebody to get a trademark on that. Whereas with the name itself, we can show, okay, here's the name. Here's where we're using it in connection with goods and services, and then we can get a trademark like that. But it is possible, especially for a sufficiently famous mark like Reese's Peanut Butter Cups. They can certainly get a trademark on the color there. Scents are another way to get a trademark. That one is, again, a little bit tricky. You have to send in examples to the trademark office. You have to be able to define what that scent is, using I don't know the name of the device that they would use for that, but there is scientific tests that you can use to classify the scent. Musical notes have also been trademarked. You remember the NBC 3 chime
Ding, ding,
pattern?
ding.
Yeah, exactly. Yeah, they had a trademark on that as well. So
Oh, wow.
it's you can get if you have something that identifies you as a source of goods or services that's sufficiently famous, you can get a trademark on it.
So what cannot be trademarked? Is there anything that cannot be trademarked?
Yeah, that's a good question. I guess there's not much as far as a blanket rule on you're not getting a trademark on this. It just has to be something that is sufficiently famous as far as being the source identifier for you. The USPTO does have some rules on like offensive trademarks and stuff like that. But generally like words, scents, sounds. I don't know about touch. I'm assuming that you can probably get a trademark on things that are you can touch and feel. But again, it has to be sufficiently famous that consumers in the marketplace recognize, like, oh, when I see that or I hear that or I touch that, I know that this is the product that it's associated with, and this is who the manufacturer is.
That makes sense. So similar to what we talked about in another episode in terms of timeline or time, excuse me, trademarks have a time limit to them?
Yeah. The nice thing about trademarks is they're extendable forever. So you just have to pay your maintenance fees. So when you file your trademark application, usually 6 to 8 months, we get the trademark approved. Then once it's issued and registered once it's a registered trademark, between years 5 and 6, you have to renew the application. Just some paperwork that you have to send in. And then at the 10-year mark, you have to renew it. 10 years from the original registration date, you have to renew it again. And then every 10 years after that, you just have to show that you're still using the mark in connection with the same goods and, pay the renewal fee.
And so similar to the patents as we talked about before, what about internationally? How does those trademarks affect you? If I patented a logo here, is that something still that works in Spain and Madrid?
Yeah, unfortunately, no. The U.S. trademark is just in the U.S. And then, but you can use your U.S. application as a basis for filing outside of the U.S. through the Madrid Protocol. And so we can, if you can get a trademark in any of those countries that you desire, but you do have to go through the trademark application and examination process.
And so just because we like to educate our audience, can you give me a basis of what the Madrid Protocol is?
Yeah. So when we file an application here in the U.S., we can file it through the Madrid Protocol, where now any other countries that want to, where you can select which countries you want to enter through that protocol. And so that then you can just file anywhere, that any member country, you can just use your application to enter those countries. You can also enter each country individually, but the Madrid Protocol just makes it easier to get into multiple countries at once.
So let's talk about that holistic view that you have in terms of your clients. What is the value of having a trademark that can go international? Obviously, the ones who are here. So we were talking before about the small businesses, but let's talk a little bit larger. What would be the advantages of having a trademark that's international for bigger organizations?
Yeah, certainly. Then you can have a consistent branding and messaging associated with your company and your products. You don't want to have to call your product, one thing over here in the US and then something else in Europe and something else in Japan. If you can have a consistent message, it just helps to build up that brand recognition.
And so that makes a lot of sense. In terms of other platforms, because I know that a lot of people like to generalize. So if you're talking about putting your trademark or your brand out on an Etsy or an Amazon, are there any things that we should keep an eye on in terms of that trademark?
Yeah. If you're doing it on your own and you want to put your brand out there, like you said, on these online marketplaces, you just want to make sure that you're not coming too close to somebody else's trademark that's already out there. You can't just change one letter and try to get around it.
That's the McDonald's.
Yes. Yeah, it just doesn't work like that. And so, if you want to get a trademark, if you come up with a new word that's not in the English language, that's usually a pretty good sign that you're going to be able to get a trademark for that word. Not guaranteed, of course, but that's usually a good way to come up with something that won't be infringing somebody else's trademark, and you should be able to get your own trademark for it.
That makes sense. So as we wrap out this episode of Secure Your Creation podcast, what are some tips that you can give them in reference to trademark that's 100% without hesitation every business should be considering?
Yeah, if you're coming up with a new product line or a new advertising line, make sure you do the trademark search. You're going to save yourself a lot of headaches in the long run by just conducting that search, making sure that you're not going to be infringing anybody else's trademarks and that you're going to be able to use that mark as your own source identifier.
Very good. Very good. And so as we conclude the show, you can always reach out to Mario at milanoip.com, in which you offer a consultation of some fashion, correct?
Absolutely. Yeah. Initial consultations are always free.
Awesome. So again, our co-host here, Mario Milano, at Milano IP. That's a lot of Milanos to be throwing out at one time. But you can reach out to him or give him a call, and he'll be happy to help you with your trademark concerns or issues. Until next time, Mario, we'll catch them on the next side and secure your creations.
Thanks, Greg.
Thank you. Bye-bye now.